Hello and welcome to this webinar on practice agreements, avoiding pitfalls. For those of you who joined a bit earlier, sorry about any technical glitches that we had. Hopefully they've been sorted out. Hopefully all the technology will run smoothly and we'll be able to give you an informative webinar. My name is Leo Briggs. I'm Deputy Head of the Dental Defence Union, and I'm joined on this webinar by my colleague Eric Easson. Just to let you know a little bit about me, I qualified in 1989, so I've been a dentist for quite a long time. I've worked in both employed and self-employed roles, and I'm a specialist in periodontics. Having worked in both practice settings and community, employed settings, I do appreciate the importance of having a good contract in whatever role you're doing. And also, just before Eric introduces himself, I thought it would be helpful to give a little bit of background about why the Dental Defence Union decided to bring in a contract checking service. There were two main reasons. One, it was an area that a lot of our members explained to us caused confusion for them. And because we are a not-for-profit organisation, we are run by our members for our members. Our members wanted us to do this. So we looked into providing this service for our members because we always like to try and provide quality services that members find of value. The other reason that we introduced it was that we appreciated that when there are strains on the contractual arrangement between practice owners and self-employed clinicians, it can have an impact both on the day-to-day work that you're doing, because it can create a strained working environment, and also that can lead to more complaints and ultimately some regulatory matters. So it made good sense for us to try and help our members avoid those problems from happening in the first place. So that's a bit of background about why we do the contract checking. And so over to you, Eric.
Hi, I'm Eric. I'm the cause of the technical glitches we got because I was having difficulty with the program we're using, but hopefully everything will run smoothly from now. I qualified from Manchester University in the early 2000s. I worked at the university for quite a long period of time. I've been an associate in several practices in South Manchester, so I had reviewed quite a few contracts in my own work. They did vary from one another, but I didn't really learn a great deal about the variability of associate contracts and the importance of particular clauses until I started working at the DDU, which I did in 2014. And I'm one of the members of the team who provide the contract advice. So I say hopefully we'll be able to provide a general overview of the importance of a fair contract for both parties. We'll look at some of the common clauses and common areas of the contracts to hopefully provide some clarification of the clauses themselves and the different terms used in the contract and why those terms are used.
Eric, just before you start delving into this, if you could give me your top tip for both practice owners and self-employed clinicians for how to make sure they're both happy with the contract.
Yeah, I mean, it can be difficult when you're meeting people for the first time, but it's really having an initial discussion of what's being offered by the practice and what the clinician wants, or what the dental associate or dental hygienist and therapist actually wants from the practice. Then following on from that, the practice using a good template and entering the details of that verbal discussion accurately. And then a contract review, and so one of the reasons we're doing this is we provide contract reviews, and it can help reassure both parties. Ultimately, then once the contract has been reviewed, both parties can then look at the contract with the review, and then discuss any concerns and consider the solutions, and hopefully finalise the contract before it's signed by both parties. So as I hopefully we'll be able to go through and explain each of the different things that crop up. But ultimately, discussion is the most important thing, making sure that both parties have a mutual understanding of what they're expecting of each other.
Brilliant, thank you.
So a comprehensive written agreement is needed to make sure that the rights, obligations and financial arrangements are clear for each party. We provide templates for self-employed dental associates, hygienists and therapists. We drafted these in association with specialist solicitors involved in this area of law. We use Hempsons for England and Wales, BTO solicitors for Scotland, and Tuans for Northern Ireland. We also check contracts against what might be considered ideal and highlight areas members may wish to discuss with the other parties prior to signing the agreement. So one of the things we do is provide the contract advice, and it is helpful to then sit down with the other party and discuss the advice that we give. How does it help? Contracts I'm sure a lot of you have come across contracts and have read them, and they are lengthy documents with multiple sections and sometimes lots of supplementary schedules or appendices. The vast majority of contracts are developed from templates supplied by various providers, including the DDU, with some areas needing to be edited by the practice owner to suit the particular circumstances of the job they're offering, and then taking into account what the clinician themselves wants. One of the things we do during the reviews is explain what particular clauses mean, if there's any vagueness in the clauses, or somebody wants to know exactly what a clause is intended to mean, or what we understand the interpretation to be, and we highlight areas which may be of particular importance to both parties. With the best will in the world, editing errors do occur, and occasionally important clauses can be altered. It's often well-intentioned to simplify the wording or to try and simplify the contract overall, but it may lead to such things as multiple interpretations possible, and this can lead to misunderstanding. So we will highlight those sorts of things for people requesting our assistance. Review helps highlight these areas, and where a discussion about the intention or intended meaning of a clause can help reduce the potential for misunderstanding and difficulties in the future, because ultimately contracts are there as a basis of as a record of what was agreed between both parties before engaging in the agreement. There are a huge number of templates available. The majority are excellent and have been edited through various versions to keep them up to date, as ours has, and wording is improved throughout the various revisions. However, there are still areas of even the best templates where they could be simplified. So wherever possible, a relaxed discussion between both parties can help, including a mutual understanding of the intention of each of the different sections or clauses of the contract, or the intended interpretation of any clause. Sometimes I still read clauses where it takes me a few rereads to actually understand what a clause is trying to get at, but I'm still often uncertain. So if it's like that for us, where we're reading contracts all the time, it is likely to be the same for practice principals and clinicians they're wishing to engage, where clauses are sometimes so ambiguous it is open to interpretation. So what's a self-employed contract for associates and dental hygienists and therapists actually for? They describe the rights, obligations and financial arrangements for both parties. Ultimately, it acts as a record of the agreement in case of future misunderstandings. The contents of the self-employed agreement contribute towards self-employment status, describing such things as clinical freedom. They shouldn't be too prescriptive, but I'll go into further detail in this in a later slide. License is a term you'll see quite commonly in associate agreements, and the arrangement is described as a license to use the practice equipment and facilities for free, because it avoids the clinician having the right of exclusive use of the surgery under the Landlord and Tenant Act 1954. It allows the practice owner to retain control of facilities and services provided, and avoids the hygienist, associate hygienist or therapist having the right to exclusive use of the surgery. Because of the license arrangement, the services and facilities will be clearly defined and described in the agreement, including the surgery, equipment, materials, staffing, and there's usually clear reference to the introduction of patients by the practice owner to the individual clinician. It will often describe the services that clinician is expected to provide in addition to that. The payment for the license is termed the license fee. So this is something that commonly comes up in questions from members seeking our advice. It's most commonly a percentage split of income, with one proportion of the split going to the practice owner, which is termed the license fee. There are multiple methods to calculate a license fee, and they can be complicated. Because there's no single method to calculate the license fee, the contract must provide sufficient detail for both parties to be clear how the fee will be calculated. Both parties also need to be clear about the detail of the license fee calculation, given that most job offers are often made with basic percentage figures only, or just a general understanding of what the practice principal is wanting to offer to the clinician without detailed description. So the contract should then go into further detail. It needs to detail all of the relevant income, such as private fees, NHS payments, any deductions such as laboratory fees, pension contributions, things like bad debts where patients don't pay the fee attributable to any treatment that's provided. All should be clearly itemised. One thing we see is missing from these from contract agreements quite often are example calculations, which can really help supplement the detailed description in the dedicated clauses in the contract, and help both parties actually understand what the license fee is, and all the various income and deductions that might be attributable to that.
So my take-home message from that is that the license fee is the crucial part of how payments will be made by the practice to the clinician, and the practice and the clinician need to really understand how that's going to work.
Yes, I mean, it's the license fee is the fee paid by the clinician to the practice for the license. So they're taking that the practice principal is taking that license fee from the clinician for the use of the services, the facilities, staffing, etc. But yes, it needs to be clear for both parties, because that is where misunderstanding does most frequently occur in our experience.
Right. Something I forgot to say at the beginning, for anyone who wants to ask any questions on the webinar, there is a box where you can post questions. So please feel free to write any that you've got, and then Eric and I will try and look at those and answer as many as we can at the end.
Yes, more than happy to answer any questions that crop up, because it is something where this is a general overview, and there are going to be some specific questions. So we answer specific questions from DDU members all the time when they write into us. But if you have any specific questions and we can answer them at the end, and it might be helpful to you, please just put them in, as Leo said, and we'll try and get to them all as much as we can. So the next section, which is obviously pertinent to self-employed agreements, is self-employment status. It's not quite as simple as being your own boss. The practice owner has a business with financial requirements to meet, and this is where commonly conflict occurs between the self-employed clinician's control and freedoms and the business requirements of the practice owner, where they obviously have payments to make on the building themselves, any leases they have on equipment, etc. So they need to have some degree of security over those the actual income that the clinician is going to generate. Why is it important? There's been increased scrutiny by HMRC, which is a non-ministerial department of the UK government, which is responsible for collection of taxes recently. So it is something that has gained more notoriety recently because of this increased scrutiny. IR35, you'll probably hear that quite often, and that's effectively a set of rules for work that is considered off payroll, which means it's provided by someone who is not a direct employee of the business. These changes were introduced in April 2021 to tackle tax avoidance, and the wording of relevant parts of the contract needs to be carefully considered and accurate to reduce the potential of HMRC if they were to review the contract, taking the view that the associate is actually employed rather than self-employed in any review. This includes such things as freedom or limited control of the clinician by the practice owner, which is one of the key elements for the assessment, as are financial risks for the clinician, which is common for the licence fee arrangement, given the amount retained by the clinician varies dependent on the work undertaken, so the number of patients they see and the fees taken for that particular work. The ability to appoint a locum to fulfil obligations of the contract is another key point, which we'll come into in more detail later as well. But that's the ability to appoint a locum is one of the key fundamental rights for being self-employed.
You were saying earlier that a lot of the contracts are based on templates. In your experience, with these types of clauses around the self-employment status, which are the ones which practices and clinicians like to amend the most? Which are the ones that you think people have most concern over and like to try and change?
Yeah. Most recently, I think I've seen in the recent contract reviews I've undertaken, it's been the locum clauses that have been amended and removed. There's a degree of misunderstanding about who's engaging the locum, and I think it makes both parties a little apprehensive about having them in a contract, because it's often thought that the locum is engaged by the practice, but it's actually the clinician who is engaging or should be engaging the locum to then fulfill their obligations under the contract for the practice owner. So it's something that does cause a little bit of concern, and they're often removed from a contract without realizing how key they are to self-employment status. So we do see quite a few contracts with the locum clauses being removed or amended to a level where it might not be consistent with what would be expected for a self-employment contract. So that's the most common thing we see.
So I guess that all our members should get financial advice from financial people about ensuring they are self-employed, both the practice owners making sure the contract meets their requirements to ensure the clinicians are self-employed, and the self-employed clinicians getting advice on those sort of this side of things to make sure the contract does confirm that they are self-employed.
Yes, I mean, one of the key things about being self-employed is if you're employed, tax is deducted at source. When you're self-employed, it isn't deducted at source as it would be for employees. So it's important for clinicians to get specialist dental accountant advice right from the outset of their career, or when they embark on being a self-employed clinician, so that they are aware of all these different things, and then accountants can give quite detailed advice on self-employment status and what is important to consider in that. Because one of the main financial differences is that, as I said before, tax isn't deducted by the self-employed. When the self-employed clinician receives payment, it's paid later by the clinician. So engaging an accountant early will be able to give you a good idea of what your tax liabilities will be in the future. practice owners, following on from this, practice owners are then not liable for national insurance contributions, and both of these points are commonly referred to in specific clauses in the vast majority of contract templates we see. So there will be specific clauses relating to tax and national insurance payments. Sometimes the term indemnity is used for this, where the contract states that the clinician needs to indemnify the practice owner for tax and national insurance contributions. It is a confusing term because obviously indemnity providers like the DDU and the other defence organisations provide indemnity, but it effectively simply means that the clinician needs to pay both of those things themselves. The contracts normally stipulate, again, in individual contracts, that the associate hygienist or therapist is liable for tax and national insurance contributions. There are usually a number of detailed clauses relating to each of these different areas. So in addition to the tax and national insurance financial elements, there are other key areas in contract templates, such as a clear statement that the clinician is to be viewed as self-employed, or use of another term such as contractor. These usually happen very early on in the contract, where the clear statement is often from the very early clauses in the contract, and a clear description of what the license is actually for. I touched on this briefly in an earlier slide, but it's also common for freedom to be made clear both clinically and in terms of time. So you have clinical freedom and in terms of how often you would use the facilities, often used with careful phrasing, and the ability to appoint a locum to fulfil the obligations under the contract. As I touched on before, ultimately the practice is a business, and so they will be working to strict budgets, which include materials, staffing levels, laboratory fees, all need to be considered. Therefore, a degree of mutual understanding and possible compromise can help both parties reach a mutual agreement of what would be acceptable to them. Most contracts will be worded carefully to try to make sure the arrangement is fair for both parties. So although there's a degree of freedom in most contracts we see, the use of the practice facilities should be clearly defined. Phrases such as the surgery will be made available for use rather than must use the surgery between these hours sometimes places an obligation for the clinician to use best endeavours to use this surgery for a full period of availability. It helps try and avoid being too prescriptive of the times that the associate must work. So it conveys a degree of flexibility for the clinician. Contracts will also commonly set out arrangements and sometimes charges for the clinician to use the surgery outside the defined hours. This is sometimes something we come across in contracts of, and it's sometimes ambiguously worded, where there is a charge for using surgery outside the defined hours of the opening of the surgery, but it's not quite clear whether that would apply to the late running of a session or whether it is using the surgery in the evenings or at weekends. So that's sometimes something we commonly indicate needs to be clarified with the practice owner. To reduce the risk for both parties, that the use of employment terms such as the granting of holiday time, which may suggest that the agreement is more akin to employment, instead of using those terms, they use the more generic reference to things like time away, planned unavailability from the practice, or they specify a minimum number of weeks that the facilities must be used per year. It's quite clunky wording, but that's why contracts use this sort of wording rather than just using basic terms like holiday and how many days holiday am I going to get per year. That's why it's phrased in that way. It's to try and avoid the use of holiday time, which is used in employment contracts. It's common for clinicians, particularly dental associates, to provide emergency treatment to patients outside the normal surgery times. So these are often clearly defined in contracts. if they aren't, it's always advisable to discuss with the practice owner what's expected of them in relation to emergency treatments. Is there an emergency rota, and requesting sight of the emergency rota to make sure they're happy to agree to that is often a good thing to do very early on in the discussions, just to make sure that both parties are fully aware of what's expected of them early. So going back to the fundamental right of a self-employed clinician being able to substitute a locum to fulfil the obligations the clinician has under the contract. Although we do see some contracts, as I said earlier, during our reviews without locum appointment details, they are infrequent because of this right. Commonly, these clauses are removed from a template without knowing that it's an important area of the contract, particularly in terms of the self-employment status of the clinician. They're usually defined within a dedicated section of the contract, and they set out such things as how many days, after how many days the locum would need to be engaged, how they could be engaged, whether it's by the practice owner or by the clinician, because sometimes the clinician, if they are off work for a long period of time, it's often due to illness and they're not able to engage a locum themselves. So it will often stipulate both ways a locum can be engaged, and then the financial arrangements for actually paying the locum would usually be clearly set out. Occasionally we see contracts where if, as I said before, the normal way of dealing with things is for the clinician to engage the locum themselves. If they're not able to, then and the practice engage the locum, then there will often be a charge for the practice to engage the locum. But again, it's usually clearly defined and something that we highlight during the reviews that we do, where it's not our template being used. We'll highlight that so that can be considered during the discussions. Termination of a contract is something that it's difficult to discuss between both parties. It's something that's often carefully considered by the clinician considering terminating the contract. It's something that causes disruption in the practice. The practice principals are often concerned about when that actually happens, and it's stressful and unsettling for both parties. Having a clear definement that defines the process should help guide the different areas to consider when the event actually happens, so when the clinician gives notice that they wish to terminate the contract, or the other way around. So all agreements should clearly set out the notice periods for either party to terminate the agreement. This period varies enormously between the agreements we see. There is a general average for what the notice period is, but it does vary between agreements, and it's most common for the period to be the same for the practice owner or for the clinician to terminate the agreement. It's usually the same, but we do see some unusual variations where it is shorter for one of the parties for one reason or another, and that's something again we highlight so they can discuss the rationale for that with the practice owner. One of the things that does come up quite often and can be missed by people where they don't get reviews for contracts are earliest termination dates. They are common for us to see in the contracts we review, and so if the notice period is 3 months, there will often be a separate clause which indicates that the notice cannot be given before a particular date, which can be a year, often 2 years, and it is something that it's becoming increasingly common in the reviews that we do. It might be due to the disruption it can cause to the practice when clinicians leave. It can also be due to the costs involved in recruiting and the general difficulty of recruiting dental associates, dental hygienists and therapists. It is difficult for practices in particular locations to actually get staff. So it is often in those sorts of contracts where these difficulties, where practices have experienced these difficulties, use these sorts of clauses in their contracts. If they are used, they should be clearly defined and easy to find within the document. Although it seems sensible for these to be set out in the termination clause of the contract, we do see these spread out in completely unrelated parts of a contract. So they can be missed quite easily with a general read. It's very easy for us to miss. We obviously go through everything very in fine detail to try and find anything like this that might be relevant to our members. But we do see them in unusual areas, and I don't think it is something that's done on purpose. I think it is just something that where practices have considered these different the different things that they need to secure their business, and they then add them into a contract at a later date without thinking where it might be easiest to find or where it's relevant to. But it is something that needs to be found and then considered with the practice owner when you're considering the agreements together. With these earliest termination clauses or minimum terms, there are often financial penalties if the contract is terminated by the clinician during that period, and it's most common for the contract to require the departing clinician to cover things like recruitment costs incurred to recruit them if a recruitment firm was used. Sometimes the costs are very, very high. So we commonly see that the earliest termination period might be for, say, 12 months. And for the first 6 months, they're liable for 100% of the recruitment costs. If they terminate the contract after between 6 months and 12 months, they're liable for 50% of those costs. After that, they're not responsible for the costs at all. So, although the contracts can be terminated within those periods, there are financial penalties for doing so. The majority of templates used set out clauses setting out when and how a contract can be immediately terminated by either party. It's common for between all contract templates. Some are unusual. Some of the immediate termination clauses are unusual. Things such as overperformance of UDA targets is one example that we see, which is quite unusual for a very efficient dental associate or therapist performing treatment under NHS provisions. You would think that overperformance might be a good thing, but there are some unusual clauses where this is stipulated in the immediate termination clauses where the practice owner could take this action. It's unlikely, but it is there, and it's something we highlight quite often in contracts we review. These clauses will also commonly set out the arrangements for the continuing care of patients as well. So it's most common for the care for the departing clinician's patients to transfer to the practice owner. Some contracts set out exactly what treatment the clinician is responsible for completing when they terminate the agreement. Things like orthodontic treatment, where it's lengthy treatment, there will often be arrangements set out in clauses in the contract defining what the clinician is responsible for and how the arrangements will pan out when they leave the practice. And it's often the facilities will be made available for their use through mutual agreement. So it leaves it open to both parties to sit down and agree what's going to happen with completing those treatment plans for patients. But that's the most common scenario we see.
I've got a few questions about all of these things because I know that they can cause quite a lot of confusion. So with a minimum term, so say there's a minimum term of 6 months, does that mean that you can't hand in your notice until after that 6 months? And then if you've got a 3-month notice period, you can hand in your notice after the 6 months. So in effect, it's 9 months. Is that what a minimum term is?
Yeah. They vary enormously in the wording, and it's really dependent on the particular wording of these clauses in right. your particular contract. So sometimes the minimum term clearly defines that notice cannot be served before 12 months. So it is then effectively 12 months plus the 3 months or whatever the notice period is after that. Some will be ambiguously worded where there is a minimum term of 12 months, but it's not clear whether you could hand the notice of 3 months in at 9 months and then effectively leave the practice at that minimum term. So it is something that we do see varying wording. Some are very clearly defined, and it's absolutely clear to anybody who reads that what it means. Sometimes it's so ambiguous that we ourselves don't know when we're reviewing the contract, and we have to say, this is what it might mean, this is what you need to consider with the practice owner and agree what this clause is actually going to be what the intended meaning is. So whether this minimum term is the minimum term plus the notice period, or whether it is the minimum term with the notice period also taken into account.
So if in doubt, discuss it and clarify it is the important thing. Yeah.
So they do vary, and sometimes with the best will in the world, the practice owners will be using templates where sometimes that they're not completely clear when actually these things are highlighted what this means. So it helps both parties just agree, yes, I think that's reasonable, I think that's reasonable as well, and then they can come to a mutual agreement of what these actually mean. Because even though these templates have gone through various versions and people have looked at the wording and tried to improve it, there are areas of pretty much all agreements that we see where there is some interpretation and some variability. So it is, if both parties agree, that's ultimately what a contract is for. It's for both parties to agree what they are, what the process is going to be for all these particular things.
And then the other thing, the immediate termination clauses, I assume that usually it's something pretty significant that you can terminate immediately for either the clinician or the practice owner.
Yeah, again, these clauses can be vaguely worded. We often see the phrasing material breach of a contract, and it's not clear sometimes to either party what a material breach might be. Right. A breach of a clause might be minor or it might be significant. So it is, again, open to interpretation. Having a discussion about what they might consider these different things to be really does help. Because I say some of these clauses are very extensive, where they do go through. There are so many different things listed that might not be particularly relevant to the actual situation that the practice owner of the job that the practice owner is offering to the particular clinician, that they need to have a discussion about what these clauses are, how they might be implemented, and what each party might consider the definition to be. That really does help, because then there's if something ultimately bad does happen and the contract has to be or one party considers the contract needs to be immediately terminated, then it's not a surprise to the other party when that happens, if they've had the discussion early on about what that might be.
Yeah, thank you.
So going on to the protection of goodwill and restrictive covenants, these are other clauses that come in the same section of a contract as the termination clauses. So it's effectively that they are protecting the goodwill is the business owner's assets for the practice, which is the goodwill for the actual patients that the associate's treating. That is owned by the practice owner. So although they can seem very, very restrictive to a departing clinician who might have set up home near a practice and would like to move to another practice nearby, possibly in the future, they're intended to protect the practice owner's business. They need to be carefully considered when signing an agreement, because these clauses usually define the period and the radius or area within which the clinician agrees not to work following the termination. So if the restricted area is particularly broad for they do vary enormously between urban areas and rural areas, but if it is seen to be particularly restrictive, there may be some scope to negotiate, depending on the particular circumstances of the job being offered and the particular circumstances of the clinician who's wanting to start in that role. So although there's some debate over the possible enforceability of these clauses, they should be considered to be legally enforceable, because of the potential for them to be enforced if a legal dispute did arise in the future. So they need to be carefully considered with regard to future career plans for the clinician. These clauses also usually refer to the clinician agreeing not to specifically entice patients or staff to follow them. And this is because often we see the situation quite commonly where a dental associate will want to set up their own practice in the future, and they set up nearby. They know they've got very, very good staff in that previous practice, and they want to try and move elements of the practice they've worked in with them. And they've treated patients often for a number of years. They want to move staff and move patients with them. But these clauses are specifically there to protect the practice owner's business. So although they can seem restrictive, they are there for a purpose. This is another area of the termination clause of the contract, which creates some discomfort for associates and dental hygienists and therapists, which is leaving retained fees with a practice, because it can be a large amount of money to anybody, the amount of money that they're leaving. So nobody wants to think of their own work will fail, but ultimately it can, and it does, and leaving retention fees with the practice can help facilitate remedial treatment provision, which also helps reduce the potential for complaints and claims if things can be dealt with quickly by the practice. So leaving these fees can help with that. The calculation of these fees varies between contracts. Some will specify a fixed amount. Some will work on the basis of a percentage of gross fees over a particular period. They do vary. Ultimately, if the amount of money is properly managed, leaving funds can help reduce the potential for complaints, claims, and clear detail in the contract can help misunderstandings and difficulties in the future with how that money will be returned to the clinician, which is the period varies, but it's usually returned in equal tranches after a particular period. So after 6 months and 12 months, the clinician will receive a particular percentage the period of retention of the funds should be clearly defined, and how the money will be returned to the clinician at the end of that period. And it can be a difficult area for discussion because there is a degree of trust needed that the fund will be managed carefully by the practice owner and the money is returned. So again, we keep going back to this, but from the outset of considering the job the clinician wants to take and the offer that the practice owner is making, a detailed discussion when considering the contract from the outset can help. Open and regular communication during the retention period can help reduce the potential for misunderstanding and problems with how that fund's being managed. It also gives from the general aspect of the DDU as an indemnity provider, we do see complaints coming in where the clinician hasn't been informed about the complaint early on, where the retention fee might have been used, but then the actual complaint itself hasn't been notified to the associate. The fund's been used, the actual fund's been used for the complaint that the patient has made, but the clinician's never been informed about the complaint and being given the ability to respond to the complaint if needed. So keeping open communications between both parties can really help reduce the potential for matters to escalate.
I guess it's a really difficult thing to discuss when you're applying for a role about what's going to happen when you leave. It's not a normal sort of natural discussion to have. Yeah. So would you say it's really good for both parties to think about those things and not be put off if somebody is discussing that when they're applying for a job?
Yeah, I mean, certainly, I mean, having an agreement of what happens, I mean, hopefully, I think everybody goes into agreements thinking this is going to last forever. The practice owner wants an associate there for the length of time they own the practice. The associate or dental hygienist and therapist want a job for a long time, so they've both got security and stability. But having discussions about what happens in the worst case scenario, which is leaving the practice, really helps both parties just be comfortable overall with what's going to happen if that does occur. Because if there are fallings out, which happens, it is then there's a clear agreement between both what's going to happen. Both have had a discussion early on, so there's a mutual understanding of what happened, what the retention fee is going to be, how it's going to be used, and then hopefully communication can stay open between both. So it can be managed effectively, and the clinician can be notified about any difficulties that arise. Because I think any clinician, I'm an active clinician, I want to know about any difficulties that happen with my work, just so you've got the opportunity to A, learn from them, and B, deal with any problems with patients that might arise. And you've got the ability to deal with things how you would like rather than how somebody else would like. So I think open communication is good at both ends of the spectrum, when you're looking at the contract, and then later on when you're actually dealing with these retention fees and you've departed from the practice. So the next thing, just going to briefly touch on vicarious liability, which is a specific term used for legal action attempted against a practice owner for treatment carried out by a self-employed independent clinician who worked at that practice. Most of the frequently used templates make it clear the clinician should be adequately indemnified for the work they carry out and require that they provide evidence before they start working at the practice. As we're all aware, it's also a GDC requirement for registered clinicians to declare that they are indemnified for the work they provide. Therefore, all clinicians working under these self-employed arrangements must be, and checks are made to make sure that they are indemnified for the work they carry out. The problems arise when the departed clinician is not contactable after they leave a practice, and it may leave little opportunity available for patients to try and seek recourse if they're unable to contact that individual clinician, or the practice is unable to contact that clinician. So it's sensible for the clinician to keep the practice up to date with their contact details if they change, so that they're informed about any difficulties early and can seek advice from their indemnifier as early as possible. Vicarious liability is a standard benefit for practice principles of DDU membership as well, but this is, again, it's referred to often in contract, not always, but it's becoming increasingly frequent in contracts, and it's referred to in different ways. So one of the things we do is explain what the vicarious liability is, what indemnity the DDU provide, and then explain in a general way what vicarious liability and what benefits of membership the member may have. I think Leo's going to expand on vicarious liability now as well.
Yes, yeah. I mean, for any practice owners out there, it's important that you're aware of the fact that as an employer of staff, you automatically have vicarious liability for all of your employees. When I say that, our boss, John Makin, always gets the heebie-jeebies because he starts thinking, oh my goodness, I'm responsible for what Leo's saying and doing, which gives him a bit of a few sleepless nights, but that's by the by. So yeah, you know, sort of all of the nurses, reception staff, etc., who are employed by the practice, you as a practice owner have that vicarious liability for them, and your DDU membership does provide you with that indemnity for the acts and omissions for clinical negligence of the employed staff. With the self-employed clinicians, it's essential that practice owners check that the self-employed clinicians have adequate and appropriate indemnity in place. So build those checks into your normal routine checks that you do as part of your practice admin. And for the clinicians, don't worry about the practice asking you regularly to show that you've got indemnity. It's a good thing for the practice to do. So don't worry about being asked those questions regularly. And also being asked to prove that you're still on the GDC register is something as well that practices need to do. To check that they're operating effectively and appropriately. What happens if there is if you receive a letter from solicitors saying about that they're making a claim against you for something that a clinician did, is that get in touch with us straight away, and then we can guide you through what to do. But basically, what happens is the defence organisations spend quite a lot of time tracking down the clinicians wherever possible, so that the claim is directed appropriately at the clinician who provided the care. Because as clinicians, we are responsible for the care that we provide a patient. So it's right that we should be involved in any claim that is made against us. So practice owners, if you do get that sort of letter, just get in touch with us and we can guide you through the process. As Eric said, one of the difficulties can be if somebody goes to ground. So again, for both sides, because it's horrible if you are a clinician and you hear really late in the day that somebody's unhappy with the work you did or making a claim against you. So make sure both clinicians and practice owners that you have contact details for departed staff, so that you can easily get in touch with them if the worst comes to the worst and there is a complaint or claim.
Yeah, I mean, just to add to that, it's obviously increasingly common for departing clinicians to disappear to the paradise of Australia or New Zealand and not give a thought back to any work that they carried out in England, and not be contactable because all their contact details changed. So just keeping your contact details up to date so practice can get in touch with you. So then you can, from a clinician's point of view, just so you can contact the DDU to get advice on any of these different things that arise, can certainly help deal with them at an early stage. So ultimately, as we've said a few times, being able to have a two-way conversation about the agreement can help. So it's in the interest of both parties to be open to a discussion about any of the contract clauses, any concerns, and consider any possible remedy together. So if there is a takeaway message, it is having a two-way conversation about the contract. Any concerns that you have, because they are often remedied during the discussion, where it can be explained why these particular clauses are in place, or why this clause is helping to protect the business, and once that explanation is heard, often it will help reassure either side. So we are available 24 hours a day for advice, 365 days a year. So please don't hesitate to contact us for any advice on any matters that arise. But say we also provide contractual advice. So if you'd like our advice, please don't hesitate to contact us.
I'd just say it's ideal to contact us between 8 and 6, although there's 24 hours, 7 days a week, every day of the year. The time when the advice lines have most members of the team on it is between 8 AM and 6 PM. If you need to contact us for anything urgent between 6 PM and 8 AM, we are there for that, but it does take a little bit longer to speak to someone. So please, always, wherever possible, try and phone between 8 AM and 6 PM. Right. Thank you for that, Eric. There have been a few questions. There's one which I think is very easy to answer. Does subscription cover contract questions? The answer is yes. You're as a member of the DDU, you are paying for the contract checking service, so please feel free to make use of it. Then there's a couple who were still a bit confused about the license fee. So hopefully I can try and summarize it, and then Eric can correct me when I get it wrong. Basically, the license fee is the amount of money that the clinician is paying to use the practice, and the practice use that license fee to provide the services for the clinician. So providing the staff, providing the equipment, providing the materials, etc. And that's in essence what the license fee is. But because you're self-employed, it's sort of back to front. Normally you would expect deductions to be taken off by an employer for the things that they need to pay for, but in this it's and they would do that by changing your salary. but and your salary would, those deductions would have automatically been taken off the business running costs, and then you get your salary. With this, it's sort of the other way around. You're paying for them to provide you with service. Is that correct, Eric?
Yeah, it's an odd term, and it's really where you are paying for a license to use the facilities for particular days of the week between particular times. So it's a license for you to be able to use the facilities, and sets out what that license is for. And the main object of it being called a license is so that it avoids the right of tenure. So for you being considered to be a tenant of the practice, where it's effectively to protect the practice owner. It's a clumsy term, but it's a generally used term for self-employed agreements where it's termed a license fee. I might have explained it a little bit clumsily in the presentation, but it was just to try and, because we do get questions quite commonly about why is it called a license fee, what's the license for, and it was to try and explain that. But it's a term used for the amount you pay to use the practice to treat patients.
Lovely, thanks. There's another couple of ones which I think are quick and easy to answer. One, do you help with contract framing for practice owners? So yeah, we have template contracts. We've got them for hygienists and therapists, for associates. We've got them for mixed practices. We've got them for private practices only. And we've got ones for England and Wales, Scotland and Northern Ireland. That's correct, isn't it, Eric?
Yeah.
Yeah, so yeah, in short, we've got them. Yeah, and then also, I guess tied in with that, how can a member access the contract checking service? Well, if you want our template contracts, just send us an email, address it to ddu@theddu.com, and put contract checking service on there. The same if you want your contract checked. So if you want the template contracts, just pop us an email and we can get the template contracts out to you. If you want to access our contract checking service, best thing to do first of all is phone us, and we can talk through any specific issues about your contract, and we can provide you with some advice, so you might not need to send it in, but also we can explain how long it's likely to take to get the contract back to you at that time of the year. At the moment, it's a busy time of year because there's a lot of people change jobs at this time of year, people finishing FD and VT, therapists finishing their initial training and going into the workforce. So it's a busy time. So it might take up to 2 weeks for us to get something back to you at a busy time like this. So always, always, always just give us a call first of all. And then we can talk through some of the issues and also explain what to send us and what questions to ask. Another one now. I was never given a contract, just a verbal agreement. I've never had any issues with the practice and have been working with them for a long time. Do I need to request one? Oh, that's an interesting one, Eric.
It's a difficult one to answer, to be completely honest, because contracts are really there for in the event that a disagreement occurs. So if there is a conflict between both parties, it sets out what the agreement was before you started. If both parties are completely reasonable throughout, and there is a mutual agreement throughout, then obviously there's no conflict, and it wouldn't matter what's in the agreement if both in the contract if both parties agree what's going to happen with things like retention fees, or if there is going to be one at all, and what's going to happen from there on. From our perspective, ideally we have to say have a contract, because relationships do break down. It is your reassurance that there is a contract in place. You can rely on that. So if a review of the contract and a dispute did happen, you've got the contract to rely on. So we can only advise that, yes, it is always preferable to have a contract in place, because even if you are getting on very well now, the opportunity might, or the circumstances might arise in the future where a disagreement happens, conflict arises, a dispute arises. If there isn't a contract in place, the dispute is very difficult to try and mediate in the sort of first instance, and then if a full dispute does happen, and worst comes to worst, and a judge looks at the overall agreement, verbal or otherwise, it's very difficult for them to try and decipher what's happened. So a contract certainly helps make everything very clear to everyone involved.
Thank you, Eric. I think we're now out of time, so I hope this has been helpful to people. Other questions that we've been sent that we haven't had time to answer, we will try and answer in due course, perhaps with frequently asked questions or on our website. But yes, thank you everyone for attending. I hope you found this helpful, and enjoy the rest of your time, and make sure you have a good contract that you're comfortable with.